Imagine scrolling through your social media timeline.
Ah, which is often a rather precarious activity these days.
Indeed, it certainly is. But imagine scrolling through only to discover your spouse publicly celebrating a pregnancy, and you see the pregnancy is with your best friend.
Goodness, that is a devastating scenario.
It is entirely devastating. And in South African family law, exactly how much is that specific digital humiliation going to cost them in a divorce settlement? Welcome to our legal analysis today.
Thank you. It is a pleasure to be here to examine this.
Today, we are looking into the evolving threshold of substantial misconduct. Specifically, we are examining this under Section 9 of the Divorce Act. Our mission for you today is to explore the mechanisms of how the digital age transforms a private marital betrayal into a highly public spectacle.
Right. And crucially, precisely how our courts are now translating that public humiliation into actual financial forfeiture.
Exactly. We are relying today on excerpts from a recent, highly detailed legal analysis titled Infidelity and the Evolution of Patrimonial Benefit Forfeiture.
It is an exceptional legal development to witness, really. But, to fully comprehend the gravity of this shift in our jurisprudence, we must first understand the foundational mechanics of the Divorce Act itself.
Right. Particularly how assets are typically divided when a marriage dissolves.
Precisely. Under normal circumstances, depending on the marital regime, whether it is in community property or out of community property with the accrual system, there is a standard mathematical division of assets.
The law generally avoids punishing either party financially, does it not?
It does. It operates on a principle of equitable distribution. However, Section 9 exists as a specific, highly regulated exception to this rule.
A very strict exception.
Indeed, it allows a court to order that one party forfeits their share of the patrimonial benefits if the court determines that, due to very specific circumstances, they would be unduly benefited.
And for decades, the threshold for applying that exception was fairly straightforward. There was a time in our legal history when the mere act of adultery was essentially an automatic trigger for a financial penalty.
Yes, historically, fault was the absolute primary driver in divorce proceedings.
But the legal landscape has shifted profoundly since then, right?
It has shifted immensely. As society evolved and as our law transitioned toward a no-fault system of divorce, the courts began to recognize that marriages fail for deeply complex, multifaceted reasons.
So infidelity is no longer an automatic penalty.
Quite right. The Supreme Court of Appeal established long ago that adultery, occurring in isolation, does not automatically constitute substantial misconduct. Infidelity became viewed as a symptom of a broken marriage, rather than the singular punishable cause of it.
I see.
So, for a court to deviate from the standard division of assets today, the offending spouse's behavior must cross a very high threshold. It must be so egregious, so far beyond the pale of ordinary marital breakdown, that it actually offends the court's sense of justice to allow them to walk away with their full financial share.
Which brings us directly to the landmark ruling delivered by the Gauteng Division. This serves as the focal point of our analysis today.
Yes, the case of EM versus SM. That is, case number 096891/2024. Specifically, a 2026 judgment.
The court in this matter was forced to interpret this exact threshold of substantial misconduct. But the facts presented to the judge, well, they went far beyond closed-door infidelity.
They absolutely did. We are looking at a deeply aggravating set of actions here.
The wife in this marriage did not merely engage in an extramarital affair. She engaged in a continuous relationship with the husband's close friend.
Yes.
She then conceived a child outside of the marriage as a direct result of that relationship. And then, crucially, she proceeded to publicly broadcast and celebrate this event.
That right there is the defining factual matrix of this judgment. AMJ was tasked with determining whether this specific sequence of events elevated the infidelity from a standard marital delict into the realm of substantial misconduct under Section 9.
And the court was quite decisive, was it not?
The court was unequivocal. The ruling illuminated a critical point of law. Substantial misconduct fundamentally transcends the near physical act of the affair itself.
It is about the context.
Exactly. It is the surrounding context, the intent behind the actions, and the resulting damage to the non-offending spouse that the court must meticulously evaluate.
Okay, let's unpack this. We really need to understand the underlying mechanism of why the law treats this differently.
Please do.
Let us look at this through the lens of a formal joint enterprise, perhaps a corporate partnership. If two directors are running a company and one director secretly breaches their fiduciary duty by siphoning off clients, there are standard legal remedies to address that financial injury.
Right. It is a private breach of trust.
Yes, a private breach. However, if that same director orchestrates a highly public campaign, taking out advertisements, speaking to the press to actively humiliate the other director, and deliberately destroys the company's goodwill in the open marketplace, well, the court assesses the damages in an entirely different manner.
Because the nature of the damage has changed.
Precisely. The legal mechanism shifts from merely addressing a breach of contract to actively penalizing the malicious destruction of the partner's standing and dignity. Is this not exactly what BAMJ is doing here? Recognizing that the public spectacle fundamentally alters the nature of the offense.
What's fascinating here is precisely how accurately your analogy maps onto the court's reasoning. You see, the court recognized that the broader ramifications of the wife's actions, specifically that public dimension you mentioned, were of paramount importance to the legal outcome.
It wasn't just a private affair.
No, it was not simply a matter of personal betrayal occurring in private, which the law has already decided is not enough to warrant forfeiture on its own. The judgment explicitly noted that her conduct served to intentionally humiliate the non-offending spouse.
Humiliation as a legal factor.
Yes, because under South African law, dignity is not merely a social courtesy. It is a foundational, constitutionally protected right. When a spouse deliberately moves the needle from the private collapse of a relationship into a highly visible public spectacle of marital destruction, they are actively attacking that constitutional right.
So the court viewed the intentional public humiliation as the central defining component that elevated her actions to substantial misconduct.
Precisely.
But, let us challenge that concept for a moment. A broken heart is a broken heart, and betrayal is painful regardless of the venue. Are we suggesting that the courts are now formally quantifying dignity? Are they translating the scale of social embarrassment directly into rands and cents when dividing a pension fund?
Well, that is exactly what Section 9 requires a court to do when the circumstances demand it. It is not about putting a price tag on a broken heart.
Because the law avoids emotional quantification.
Indeed, the law is notoriously detached from emotional injury in divorce proceedings. Rather, it is about recognizing when a party has acted with such malicious disregard for their partner's social and psychological standing that allowing them to claim an equal share of the joint financial assets would be fundamentally unjust.
So financial forfeiture is the lever.
Yes, the court is utilizing financial forfeiture as the only available legal lever to penalize the severe public infringement of spousal dignity.
And that public infringement brings us directly to the specific medium that amplified this misconduct, the digital sphere.
A crucial element of this case.
The analysis text provided to us explicitly highlights that the public celebration of the pregnancy with the husband's friend, it was broadcast via social media.
Yes, it was.
We really must consider the tremendous weight of digital actions when presented in a court of law today. Social media is not a private conversation over a garden wall. It is a permanent, infinitely scalable broadcast.
It is entirely permanent.
So does the court's explicit focus on the social media aspect indicate that the public humiliation, the digital footprint, weighs just as heavily, if not more heavily, than the original infidelity itself?
It absolutely does. And this is perhaps the most critical legal assessment demonstrated in the judgment. This case reflects a rapidly evolving legal landscape that is entirely shaped by the digital age.
The anatomy of humiliation has changed.
Profoundly so. The permanence and reach of social media fundamentally alter that anatomy. Look, in decades past, community gossip was localized and fleeting.
Right, it stayed within a small circle.
Exactly. Today, an announcement on a digital platform creates an indelible, searchable public record of the husband's humiliation. The judgment demonstrates definitively that the severe ramifications of public humiliation, particularly when broadcasted to a wide digital audience, are no longer viewed by the courts as merely tangential to the divorce proceedings.
They are central to the financial equity.
Yes, the destruction of spousal dignity through digital means directly and profoundly impacts the financial equity considerations. The medium, you see, is the amplifier of the misconduct.
Having established the severe and undeniably public nature of this digital misconduct, we must examine the actual financial consequences handed down by the judge.
The actual sanctions, yes.
How did the court balance this severe misconduct against the entire historical span of the marriage? Because, a marriage is rarely defined by one single event, even an event as destructive as this one.
A very important point.
The text points out the exact penalty sanctioned by the court. BAMJ ordered the forfeiture of the wife's pension interests strictly due to the extreme gravity of her action.
Correct.
Here's where it gets really interesting. If the misconduct is deemed by the judge to be so abhorrent, so damaging to the core of spousal dignity as to warrant the forfeiture of her pension, why did the court not order the forfeiture of all her patrimonial benefits? Why does she not lose absolutely everything in the settlement?
Well, that precise question brings us to the absolute core of judicial equity in South African law. You see, our courts are not instruments of pure vengeance.
They must remain objective.
Indeed. Even when faced with reprehensible conduct, a judge is bound by the mandate to achieve a fair outcome based on the totality of the circumstances. BAMJ manifested a highly balanced perspective here through a principle of dual recognition.
Dual recognition.
Yes. The judge did not look at the social media broadcast in a vacuum. Despite imposing the severe financial penalty of the pension forfeiture, the court simultaneously and formally recognized the wife's extensive historical contributions to the marriage.
What were those contributions?
Specifically, the judgment noted and credited her active daily contributions functioning as a homemaker and a mother over a continuous period of 9 years.
We must explore the mechanics of how the law values that domestic contribution. It is notoriously difficult to quantify unremunerated labor within a household.
It is incredibly difficult, yes.
But by raising a child and managing the home for almost a decade, she essentially enabled the husband to pursue his career and presumably to build the very assets that are now subject to division.
That is the exact legal view of the accrual and joint estate systems.
So the court is actively weighing those 9 years of domestic invisible labor against the highly visible, catastrophic public misconduct that occurred at the end of the marriage.
Precisely. And this is why the application of the law requires such rigorous intellectual balance. This dual recognition allows for a highly nuanced approach to equity.
It prevents a completely one-sided ruling.
Exactly. By explicitly recognizing her 9 years of contribution to the household, the court deliberately mitigated the absolute harshness of the penalty.
I see.
The ruling achieved this by targeting the forfeiture specifically at the pension interest, but allowing her to still partake in other joint assets accumulated during the marriage.
So the mechanism of the penalty is highly specific. It targets a specific financial instrument to penalize the breach of dignity without entirely erasing a decade of genuine contribution.
Correct. This ensures that historical contributions are not entirely rendered void by subsequent misconduct.
It is a delicate balance.
It prevents a scenario of absolute financial ruin for the wife, while still delivering a severe, undeniable financial penalty for the public humiliation she intentionally inflicted. It is, frankly, a masterful demonstration of balancing opposing legal principles. If we connect this to the bigger picture, this ruling is deeply instructive for legal professionals.
And for individuals navigating these cases.
Absolutely. For any individual navigating matrimonial cases today, it emphasizes the absolute necessity of considering the cumulative impact of a spouse's conduct. A judge must carefully and methodically weigh the digital footprints and public spectacles alongside the quiet, daily historical contributions, rather than focusing purely on isolated incidents. The court demands a holistic view of the marriage's entire lifespan.
So what does this all mean? For you, the listener, the key takeaway is that this specific judgment serves as a pivotal reference point in our jurisprudence. EM versus SM is now a critical legal standard for future divorce proceedings involving allegations of substantial misconduct.
Especially in our modern context.
Indeed, particularly in an era utterly dominated by the permanence and the reach of social media. It establishes firmly that the manner in which you conduct the dissolution of your marriage matters immensely.
It certainly does.
Public humiliation, the weaponization of social platforms, and the deliberate destruction of spousal dignity are no longer just moral failings. They are measurable, highly consequential factors in the calculation of financial settlements under Section 9.
And they carry a heavy financial cost.
Quite right. Now, before we conclude today's session, we must formally state the disclaimer associated with our source material. The contents discussed in this rigorous analysis are intended for information purposes only. They do not constitute formal legal advice. You must always consult a qualified attorney for counsel regarding your specific legal circumstances.
This raises an important question for the future of family law.
Oh, what is that?
Well, as social media continues to irrevocably blur the boundaries between our private disputes and our public personas, will we eventually reach a point where a spouse's digital footprint, The aggregate of their posts, their comments, and their public broadcasts becomes the primary overriding body of evidence our courts rely upon to determine financial equity in the dissolution of a marriage.
A profound and entirely necessary question for you to consider as we monitor the ongoing evolution of our jurisprudence. We thank you for joining us for this professional legal deep dive. Good day to you.